Hi, welcome to today's webinar. My name is Jamie Connerman-Cease, and I am a clinical ethics assistant professor here at the Center for Bioethics at the University of Minnesota. Thank you so much for joining our webinar today. Unpacking Bedside Bioethics is a quarterly lecture series that's focused on a range of bioethics topics that always impact your clinical work. So, very focused on patients at the bedside and what's happening in the acute care setting. Today, our session is going to focus on first person authorizations of organ donation. But before we get into that with our fantastic speaker, I want to give a little background work. Specifically, let's start first with our ethics consultation info. So, if you are part of the mHealth Fairview system, our Center for Bioethics will provide clinical ethics consultation service for you. Please contact us on Vocera. This is an inpatient only service. You can message us on our secure web messaging platform. Use the clinical ethics consultation service group to get in touch with us. So, want to ensure that all the views expressed by the webinar speakers are their own. They don't necessarily reflect those of the individual Center for Bioethics faculty. We do not take positions on specific issues, and we do not endorse, we do not imply, hosting and presenting and posting these online does not imply endorsement of any views expressed by our speakers. So, as we enter the webinar today, here is the info for how to ask for help or ask any questions that you might need. If you have any questions for the speaker, please use the Q&A function to ask those questions or to let our center staff know if you're having technical difficulties. This webinar is recorded. It will be posted to YouTube. You will get an email with that link, and then you can also find that through our website, the recording. Captions are enabled. Please use the show captions feature on the bottom of your screen if you're interested in captions today. And there are 4 ways to access the evaluation that we will be sending out after today's session. There's a pop-up in your web browser. It's also linked in the presentation's details document, which is available in the chat and was a fantastic resource for background information on today's session and speaker. You'll also receive an email after the event, and additionally, you can scan this QR code. Those evaluations are very helpful. So thank you to everyone who fills those out. All right. Are you seeking credit for today's session? You can request a certificate of attendance for CEUs, complete the form linked in that presentation details document, or scan this QR code. Those requests must be submitted within 1 week of the event to receive that certificate of attendance. If you are a University of Minnesota interprofessional education student, you can receive IPE credit for this session. You have to have active status in the health professions programs, and you must participate in our 15-minute post-event group discussion and complete the reflection form. So please see the presentation details document. If you're a biomedical engineering student, you can receive credit for this event found in the quiz tab for bioethics grand rounds attendance on the assignment tab of your Canvas page. All of this is required, 75% attendance to the webinar is required to receive any certificate of attendance or credit for attending today's webinar. All right, I'd like to introduce today's speaker, my fantastic colleague, Professor Joel Wu, who is a Center for Bioethics assistant professor and a senior lecturer in the Division of Health Policy and Management at the University of Minnesota School for Public Health. He's also the co-chair of the University of Minnesota Medical Center's Ethics Committee. I'm so excited Joel is here to talk about the issue of first-person authorization and organ donation. It's an issue that we talk a lot about in our consult service, and he's a fantastic, knowledgeable resource and has fantastic expertise to share. So Joel, I will turn it over to you. Thank you so much for joining us today.
Great, thanks, Jamie. All right, so here are the disclosures. Let's just get these out of the way. I have no financial conflicts to disclose. I will not discuss off-label use or investigational use. Just to note, I am currently the Region 7 rep on the OPT and Ethics Committee, but all of these opinions are my own and no one else's. Okay. All right. We're gonna go fast. I have a lot to cover. I want to leave room for Q&A. The learning objectives today, as we publish them, are to describe ethical considerations concerning donation after circulatory death here and after DCD, first person authorizations, FPA, and the opt-in process, and thinking about the ethical disclosures about the procurement process and what they might mean. I'm hoping that we'll all be able to analyze the ethical challenges with implementing FPA in the current landscape, and that we'll be able to describe how the application of certain prevailing ethical commitments inform the boundaries of how we do DCD. Okay. Um, I also want to stipulate some things. Uh, First, I just want to establish that I believe organ transplants are good. They're good for society, they're good for patients. And we don't have enough organs right now. More organs for transplant is better. I also want to stipulate that I think that we do need to think about respecting patient autonomy both as a patient and as a donor. We'll talk about more of that later. And finally, that trust in the transplant system, trust in our country's transplant enterprise is good, and that the loss of trust is bad. About trust, I think it's important to appreciate, I think, to some extent, our current social context. The problem of trust. These are some headlines that have cropped up over the past year or so. This is in the Washington Post. This is in the New York Times. In following some of these reports and some public comments, there has been some reaction by the government that oversees the transplant enterprise and has authority over the transplant system. Um, and this has also led to a problem of trust. And this problem of trust has led to people removing themselves from organ donor registries. So this is a problem because these are the people that would have otherwise potentially have been organ donors. What I want to do is I want to try to set up what I think is a potentially major problem that might be contributing to or may seriously exacerbate a further loss of trust in what I already think we can see is, to some extent, at least a serious crisis in trust. All right, and so let's not make that worse. I want to set that up by first asking some framing questions about withdrawals of life-sustaining treatment at the end of life. I hope these questions will help us to start thinking about the circumstances where these conflicts arise in donation. Um, I've always really enjoyed these polls. Let me get to the poll here real quick. All right, poll one. Can you guys see the poll? I think so. All right, so here's the poll. First question. Do patients have an interest in the timing and the manner of their death? So when they die, particularly if they're on life-sustaining treatment, who's there, right? How it goes, even the location, at home, in a hospital, in your town, far away. Next question, do donors, people who have designated themselves to be donors, have an interest in the timing and the manner of the withdrawal of life-sustaining treatment? So this is for patients that are still alive, but want to be donors and are on life-sustaining treatment. Finally, if the donor patient lacks decision-making capacity, do their family, does their surrogate decision maker have an interest in the timing and the manner of the withdrawal of life-sustaining treatment of that donor? Let's give it another couple minutes, or not minutes, just give it a couple seconds. All right, I'm going to end the poll in a second. We've got pretty good responses, almost 500, which is great. All right, looks like the answers are starting to taper down. We have like 515 respondents, maybe still ticking up. Okay, so ask the question one. Do patients have an interest in the timing and the manner of their death? 95% of the respondents say yes. Do donors have an interest in the timing and the manner of the withdrawal of life-sustaining treatment? 92% say yes. And if the donor lacks decision-making capacity, does their surrogate decision maker have an interest in the timing and the manner of that withdrawal? Again, 95% say yes. And I would agree. Can you see the results? This is what we see. Okay, let's move on. Um, what I really want to do next is I want to present a hypothetical case to illustrate what I think the problem is. And what I mean by the donor, patient, and their surrogate and loved ones' interests in the timing and the manner and potentially the location of the withdrawal of life-sustaining treatment, and even some interventions before the patient dies, pre-mortem interventions that may be for the purposes of optimizing procurement and not to actually treat the patient, right? Not to actually do something for that patient's medical interests. So this is the case. These are the important characteristics. As a patient with a valid donor designation on their license, no one's challenging that. The patient is on a ventilator in an outstate hospital. Patient surrogates have decided that withdrawal of life-sustaining treatment is consistent with the patient's values and that the patient would not want other invasive interventions. The loved ones want to be present at the patient's bedside at the time of death. So, on the basis of that first person authorization on that patient's driver's license, the organ procurement organization asserts the following. First, that the patient's surrogate decision makers must consent to, and also that clinicians must perform invasive interventions for the purposes of optimizing procurement. Could be line placement. This could be medication, anticoagulation, for example. Also, on the basis of FPA, the OPO, the Organ Procurement Organization, asserts that surrogates must also consent to the transfer of the patient to another hospital and that the timing of the withdrawal of life-sustaining treatment would be sooner than all the patient's family could arrive. Finally, the OPO asserts that not consenting to premortem interventions, transfer, and earlier withdrawal is a violation of the patient's first person authorization and contradicts that patient's decision to donate. OPO also asserts that the failure of clinicians to enforce FPA over surrogate and family objection is inconsistent with regulations, including for pre-mortem interventions. Okay. I want you to have this case in the back of your head. We'll come back to it, but this is the kind of scenario that I'm particularly concerned about and that I think we're going to be increasingly seeing. This kind of conflict arises in a particular law and policy context. This doesn't arise in a particular vacuum. The accumulation of law and policy that has allowed for the transplant enterprise to exist also may have, as a result of changing technology and changing societal circumstances, led to some unanticipated problems, and I think it's important to understand those. So let's talk about the law and policy context. Here are the main points that I really want to emphasize, and then we'll go into some more detail. I'm going to draw extensively, in particular, on this paper from Claire O'Callaghan and Brendan Parent. And then there's also this really classic piece from Alexandra Glazer that really does a good job. The main points here about decisions to donate and organ donation. In our country, first of all, this is an opt-in system, not an opt-out system. In the absence of a decision, you don't get your organs procured. You can choose to have your organs donated by yourself, either through designation or otherwise, through an advance directive, for example. It's also possible that when you lose decision-making capacity, an authorized decision maker can make that decision for you. What's really, really important, and I'm going to say this several times, is that this is an authorization for a gift under gift law. This is not informed consent to treatment. Okay? And so when you decide to be a donor, it's an authorization. When your authorized decision maker makes the decision for you to be a donor, that's an authorization. It's not informed consent. So under the existing law, there's really sort of three categories. There's the first person authorization where you designate yourself to be a donor. There's a situation where you haven't either decided to be a donor or refused to be a donor, in which case somebody else who is an authorized decision maker might make the decision for you. And finally, there's the possibility of someone who refuses to donate and they document it. You can document your refusal to donate and nobody can overturn that either. Okay. What's also important to note here is that first person authorizations are different than authorized decision makers because the first person authorization is you yourself. The authorized decision maker is somebody who makes the decision for you if you already haven't done it. Authorized decision makers, however, are only specifically for the question of donation or not, whereas surrogate decision makers are there to make the medical decisions about your treatment based on substituted judgment, meaning they make the choices based on what they know you would have wanted as opposed to what they want themselves. Okay. I think the laws and regulations leave a gap that is creating the context for some ethical problems and potential ethical harms. Um, Specifically, I think the way the laws are written leave a gap where choices about care, premortem, and the withdrawal of life-sustaining treatment before death may conflict with first-person authorizations, and under current law, there's no clear way to resolve the dispute. The question is, what do we do when those premortem choices preclude the possibility of procurement, even though the patient has designated themselves to be a donor? This is particularly a problem because I think the basis of enforcing FPA in premortem matters is weak. And then I'll try to show that later. Um, Hopefully, this is starting to get you to have an impression of what the problem is. But what do we do when these premortem choices preclude the possibility of procurement, right? Because they can be choices that are consistent with the patient's goals and values, and that they also potentially would have wanted to be a donor. Um, so let's go to the specific pieces of law and policy and the norms that are the framework for where a transplant system exists from, and then why this particular dilemma may arise. The first is the determination of death, the dead donor rule, and the idea of decoupling. So, going to go through this fast. First is the determination of death. How do we know someone's dead? There's two independent ways under the law. You only need one. You don't need both. Under the Uniform Determination of Death Act, adopted in basically every state with only really minor variation, is that an individual is dead if the individual sustains irreversible cessation of either circulatory and respiratory function or all functions of the entire brain. For the purposes of this talk, we're only concerned with circulatory death. Okay. Next is the dead donor rule. This is not law. This is an ethical commitment. This is a norm. And this is the commitment to say that it is unethical that procurement cause the death of the donor. Procurement cannot cause the death of the donor. Corollary is that the donor must be dead at the time of procurement. Okay. This has implications when we're talking about withdrawal of life-sustaining treatment and death by circulatory criteria, because when someone dies by circulatory criteria, there's going to be at least a period of time, minimally by policy, a 5-minute standoff, where there's going to be potential damage to the organs that we're thinking about transplanting. Finally, the idea of decoupling. The concept of decoupling is a separation of policies and procedures to protect patients in their decision making about their care, and to ensure that there's trust in the system, in that the interests in donation do not otherwise conflict with, influence, or otherwise coerce the decisions about care. Okay, so the implications of this are that the decision to withdraw life-sustaining treatment must be decoupled and prior to any decision about donation. Okay, this also means that in terms of policies regarding clinical roles, you really want to avoid conflicts of interest in role. You don't want a person who's interested in donating or donation to also potentially be influencing the decisions of a patient, because you want to avoid this kind of conflict of interest that may result in coercion or undue influence. So there's a separation of the clinical roles from the people that care for the patient, and then the people that are invested in and have the authority in the role of procuring the organs. What's important here is that when we're talking about donation after circulatory death, the preceding decisions regarding the withdrawal of life-sustaining treatment and other ante-mortem medical interventions necessarily will affect the likelihood of success of procurement. Okay. Next, let's talk about healthcare decision acts. This is the basis for surrogate decision making when patients lose decision-making capacity. Healthcare decision acts they grant authority to surrogates to make healthcare decisions for patients who do not have decision-making capacity. This includes the power for surrogates to make decisions about the withdrawal of life-sustaining treatment. However, there's no detail in the law on the effect of these decisions or the interaction of these decisions regarding the withdrawal of life-sustaining treatment on organ donation and procurement. Okay. Next are our anatomical gift acts. This is the law that allows for organ donation, for someone to make a gift that is an organ or tissue. This creates the process that allows for people to donate organs. FPA is just one of the ways under law to designate yourself to be a donor. The other way is the authorized decision maker if you don't have capacity and you didn't previously either decide to or refuse to. Again, this is an authorized gift. This is not informed consent to treatment. This is the Minnesota law. A donor may make an anatomical gift. These are the ways. First one, probably the most commonly referenced, understood, probably the most commonly used, is by the indication on your driver's license application form or a renewal form. Now, this is what it looks like in Minnesota. I'm going to leave this up kind of for like a second because I really want you to look closely at this. This is an important slide. This is all you see when you make the decision about whether or not to be a donor or not. It's a checkbox. It says donor document or gift. I want my license or identification card to show that I choose to be an organ and tissue donor under the Uniform Anatomical Gift Act. The effect of this is really important. It takes effect on death, and it's also preclusive. Nobody can revoke it. Only you can revoke it, generally. Especially understanding that once this takes effect, nobody can stop an organ procurement organization from procuring the organ because revocation has been precluded. This has been something that was very purposefully written into the law, and there's commentary from the Uniform Law Commission that really explicitly establishes this as the intent. Okay. I really like this website page from the Organ Donation Alliance. They really make it crisp. How do these laws apply to DCD? First, the anatomical gift, the FPA, takes effect on the donor's death. It has no effect before death. The effect means that the gift becomes legally binding at the moment the donor dies and cannot be revoked by others. This is the preclusive effect. Now, this is different than informed consent to treatment. This is what they explain, and then we'll go into a little bit more detail. There are going to be some interventions that may include the administration of medications, line insertions, whatever. Given that these interventions occur prior to death, informed consent must be obtained from the patient's family or legal decision makers. Right? However, additional authorization for donation after circulatory death is not necessary if the patient is a registered donor. The pre-mortem interventions, you have to get consent. You don't need more authorization for the procurement because they already made the FPA, and that takes effect on death. So, as we've seen, FPA cannot be revoked on death, only takes effect on death. So, after death, organ procurement organizations don't have any obligation to honor or accommodate family objections that contravene a valid FPA. Here's the problem and here's the question. But what if the process leading up to procurement is in itself incompatible with the patient's values and choices? What if there are choices that would need to be made to optimize procurement that would violate what the patient would have wanted about their end of life care? The problem is with DCD, the decisions about the process ante-mortem right around the time of the end of life, these decisions about the process that should be governed by the patient's goals and values may, by consequence, have the effect of precluding any meaningful opportunity for successful organ procurement. This is a problem that really only arises in a particular set of circumstances. And we'll say more in a minute. It's when there's a DCD donor, there's a valid FPA, there's no healthcare directive, the patient doesn't have surrogate decision-making capacity, the patient doesn't have decision-making capacity, and we're relying on surrogate decision makers. Okay. I want to do a thought experiment. We're going to change a couple of these things. It's still a DCD donor, it's still FPA, there's still no healthcare directive, but the patient still has decision-making capacity, so we don't need surrogate decision makers. So the patient's at the end of life. They know that they want to withdraw life-sustaining treatment because they don't want to stay on it anymore. They're thinking about donation. What if we tell the patient that has decision-making capacity that if they choose to be a donor, that they would also be forced to consent to all the necessary pre-mortem interventions and couldn't refuse them? You couldn't refuse line placement. You couldn't refuse anticoagulation. You potentially couldn't refuse resuscitation. You couldn't refuse being moved to a different place for withdrawal away from family. I mean, maybe the patient would be that invested in the idea of being a donor, and they would be, okay, that's fine. I consent to all these things. But if they didn't consent to it, they could just choose not to be a donor, or they could just revoke their donor status, right? What's the difference if we're relying on surrogate decision makers? Because theoretically, if a surrogate decision maker is exercising substituted judgment, wouldn't that also hold equal weight? All right, so where is this problem coming from? And I think there's a legal gap here. I'm going to reference a paper in a minute that I think does an exceptional job of explaining what the problem is in the gaps in policy and law. But in brief, the gaps. The law does not address timing, location, or manner of the withdrawal of life-sustaining treatment prior to procurement and whether or not it affects procurement. The law also does not address non-escalation or the need for other pre-mortem interventions. The thing is, even with FPA, I think it's pretty well accepted that surrogates and family maintain the authority regarding pre-mortem patient care. Yeah, I want to keep on moving here because I want to make sure we have time for Q&A. This is the paper. It's by Claire O'Callaghan and Brendan Parent. They do an exceptional job of explaining this, and I think it's very convincing. The origins of the problem are that healthcare decision-making acts that give surrogate decision-making authority to surrogates, they do not address pre-mortem non-therapeutic treatment decisions or the withdrawal of life-sustaining treatment. So specifically, healthcare decision acts neither say that surrogates have to consent in ways that align with the first person authorization. They also don't say that their choices can be or should be superseded by the FBA. Okay. At the same time, anatomical gift acts do not address pre-mortem medical decision making, including the withdrawal of life-sustaining treatment. So anatomical gift acts do not say explicitly that the FPA is sufficient to replace consent. It does not say that the FPA is sufficient to supersede surrogate choices if they're exercising substituted judgment. At the same time, they also say that the FPA is not sufficient to supersede that. There are narrow circumstances where the withdrawal of life-sustaining treatment cannot be removed when there's uncertainty, but that's a narrow category that I sort of want to set aside. Um, so in the O'Callaghan and Parent paper, they do a really exceptional job of showing the specific circumstances where this problem arises. And it's in this red box. And it's in a situation where uh, there's not a directive on withdrawal of life-sustaining treatment, and there is an FPA. So they say it's unclear whether or not a surrogate decision maker request for the withdrawal of life-sustaining treatment can override donation if circumstances of organ donation would not be concordant with the goals of care, right? So when the goals of care, when the goals about how the patient wants to be treated at the end of life are not concordant with the intent to donate. Um, this is some language from that paper that I think is really good. If the goals of care laid out by the surrogate decision maker, which represent the patient's own wishes, conflict with some aspect of organ donation, it is unclear if those requests have any legal authority to delay, override, or otherwise influence the organ donation process. In another part of the paper, anatomical gift sacks are intended to protect the patient's right to make an anatomical gift, right? This is part of the preclusive effect. But it is unclear if this should supersede the right to determine other aspects of their end-of-life care. These other aspects are the premortem interventions and also the timing, location, and manner of the withdrawal of life-sustaining treatment, I would argue. So this is going to lead to some ethical conflicts, right? This uncertainty and this confusion is going to lead to some potential harm. And I think this ethical problem, this gap leads to a problem that I think we can maybe characterize this way, which is whose values have priority if we can't figure out how to make a decision that honors the right value or the right interests. So whose values ultimately have priority? The patient as the patient as the donor, and or the pool of people who need organs. Because it might be that if we try to respect the patient as the patient, they can't be a donor. But if we try to respect the patient as the donor, then the patient loses out on certain decisions about how things go at the end of their life. I'm going to argue that I think currently in our society, given the norms, laws, and policies that we have, that in terms of priority, it has to be the patient as the patient, not the patient as a donor. Okay. To sort of specify the ethical issues a little bit more. This is the conflict. On the one hand, respecting patient and family values about care at the end of life may contradict the intent to donate. So this is the conflict between autonomy regarding treatment and autonomy regarding donation and the value of those organs. On the other hand, optimizing procurement over objection may cause harms to the patient and the family. This is another kind of a violation of respect for autonomy, and it might actually lead to real harms, both medically and I think also non-medical harms that we'll talk about in a minute. Finally, I think the justifications for proceeding over these objections are weak. Because when we're talking about first person authorization, we're relying on that checkbox. That checkbox that I showed you in the red box earlier, that's all we're relying on here. That's all people see. How much can we infer from that? How much authority can we draw from that checkbox? It might be worth it if there's a lot of evidence that proceeding in the way that you rely on FPA to supersede these other values and goals, results in a huge increase in the availability of organs, but I just don't think there's available evidence to suggest that's true. And it may actually even backfire if there's a serious loss of trust. We already see the people leaving the donor registries, right? So another way of thinking about it is really just to think about in terms of the competing priorities of the patient as a patient and the patient as a donor. We can really sort of make two mistakes, I think. There's two paths. There's two ways to err. And which direction of error do we think is more defensible? So, first path is to optimize procurement based on FPA, superseding patient and family values in ways that would preclude procurement or at the very least limit it. So that's the first way is potentially optimizing procurement in ways that are inconsistent with what the patient would have wanted at the end of their life. Right. The other way to make a mistake is potentially to respect the patient and family's values and goals about how the patient's going to die at the end of life, although that's going to prevent the opportunity for procurement and donation. It might limit the opportunity for procurement and donation. Which way should we err? And I'm going to argue that we err in the way that is described in B. So why? Why? What are the hazards of A? What are the harms of proceeding over surrogate objections on the basis of the patient slash donor's FPA? This is also from the O'Callaghan and Parent paper. Uh, this is specifically about a kind of medical harm, but there's more than just the extension of the withdrawal of the extension of life-sustaining treatment longer than the patient would have wanted. But they say harm to the patient may include physical pain despite palliative treatments, and importantly, being subject to medical interventions that are not concordant with their goals of care, and being required to continue living in a state that they would never have wanted to be in. I think these are real harms. These are medical harms. And there's side effects and burdens of these interventions. In addition to that, I think there are some non-medical harms that are really worth taking seriously. And this is, I think, another exceptional paper that really describes the problem of the enforcement of FPA over vetoes and also FPAs as the basis to do pre-mortem non-therapeutic interventions over objection. So this is Anna Iltis and Brianna Denny. Um, this is the way that they explain some of the other harms that are not just the medical harms. Upholding FPA despite family objections could lead to distress for the family or potential harm to the decedent during the pre-mortem care. Um, Next sentence. Disregarding family wishes and the implications of first-person authorization on pre-mortem interventions could cultivate distrust in healthcare professionals who are responsible for the decedent's care and perpetuate health inequities that already exist. Here, it is important not to merely think about increasing the number of organs donated, but also to consider the potential harms that could transpire as a consequence of upholding first-person authorization in the face of family objections, right? It's not reducible just to the number of organs. There's some other considerations we need to think about. They're non-medical harms. At minimum, it's respect for autonomy in a way. There's also the question of justice and trust. Are we treating like people like? Are we taking people seriously about their interests and their goals, or are we dismissing some of their interests and their goals? And finally, there are harms that accrue that are non-medical, not just to the patient and donor. There's also the effects on the loved ones that surround them. And I think that these are legitimate interests, even if they're not necessarily observable physiological harms or something that can be remedied in, by a lawsuit. Uh, this is going to arise primarily in two settings in an ICU setting. It's going to be regarding pre-mortem non-therapeutic interventions. These are the interventions for the purposes of making the organ better for procurement, but not the patient's. And then also the timing and the manner of the withdrawal of life-sustaining treatment. Okay, First, about these pre-mortem non-therapeutic interventions. These are for the organ to be procured, not the patient. They optimize the likelihood of the organ being able to be successfully procured and transplanted. They do not benefit the patient medically. That's also before they're dead. If this is a patient that's brain dead, they're dead under neurologic criteria, but the rest of their physiology may still be able to sustain organs in a way that allow for them to be successfully procured. We're not talking about that. We're talking about donation after circulatory death. So these are pre-mortem non-therapeutic interventions for a patient that's not dead. And it's not so clear for patients that are not dead. Um, these conflicts can arise with serious interventions. These conflicts can be between a directive to refuse escalations of care or choices by a surrogate to refuse escalations of care and the FPA. And these include things like invasive mechanical ventilation, extracorporeal membrane oxygenation, code status, medications, classically anticoagulation, right? And what's at stake here is a kind of unconsented treatment because these are interventions that are happening to living patients. Clinicians are doing things to a living patient. As we mentioned earlier, and I'll show again, these should require informed consent. And the values that guide that should still be patient-based. If the patient doesn't have decision-making capacity and you have a surrogate decision maker, then the surrogate should be exercising their substituted judgment and on that basis have the authority to consent or refuse for the patient. What's really important here is to think about whether or not that checkbox is something that we can understand to be more than just an intent to donate, understanding that you can donate when you're dead. Is that checkbox something that also might imply or it could be understood to mean informed consent to treatment that would be necessary for procurement? And I don't think that holds. I think that the patient's values regarding their treatment and the circumstances of their life at the end of life should prevail. The trouble is that in the absence of a patient having decision-making capacity or a directive that governs these things, which is I can't even imagine that it would be like finding a unicorn if you could find somebody who had a directive that was so detailed about this stuff. It would basically just be an insider who wrote like a really, really detailed directive. That like never happens. It's going to be a surrogate decision maker. And that surrogate decision maker is going to be caught in this dilemma, right? Because they have to make a decision that takes into account the patient's treatment values and what they understand to be an intent to donate. What if they don't square? Um, So in these cases, the surrogate decision maker can choose not to consent, and that may preclude the opportunity for procurement. Informed consent should be required. This is something that I think has been well stated. Um, Here, the societies of anesthesiology and thoracic surgery say that additional informed consent from a surrogate or proxy is required for procedures or medications for the purposes of organ donation that occur prior to the withdrawal of life-sustaining treatment. This is from the Denny and Iltis paper. This is what they say, and I think it's very convincing. Um, so understanding that rejecting pre-mortem interventions or deciding to forego these interventions, like anticoagulation, line placement, whatever, foregoing these on living patients when doing so may render them unable to be organ donors is not a violation of first person authorization. Such decisions fall within the scope of authority and responsibility of legally authorized representatives for incapacitated patients and should not be described as overriding FPA. These are decisions about and for living patients, right? FPA takes effect on death. These are still living patients. Um, extending this argument from just vetoes and premortem interventions, and my conviction is that this should also apply to decisions on the timing, manner, and location of the withdrawal of life-sustaining treatment. The checkbox doesn't tell people how they might lose control of when, where, and how they may die if they check that box. This is the thing that might cost more than expected. You might lose control of when, where, and how you die if you check that box, and we hold that FPA takes priority over other values that are represented by you or your surrogate, right? And what I would propose to you is that overruling those values and choices is harmful. Okay, having said all that, final poll, and then we'll just jump to the conclusions. I hope I'm not going too long. All right, where is this poll? Okay, can you see the poll? Hopefully, I've been able to explain this dilemma and sort of this conflict to you. With the foregoing background. Um, do loved ones and surrogate decision makers have an obligation to consent to all interventions and choices necessary to enable organ procurement when the patient is a designated donor or has an FPA, right? This is essentially the question of how much can we rely on that designation. Second question is, should clinicians and OPOs perform interventions and proceed with transfer and withdrawal of life-sustaining treatment over the objections of surrogate decision makers on the basis of the patient's FPA? I'm so curious to see how this plays out. Um, because this is in question, right? Got about 400. I'll give it another couple seconds. All right, we're like at over 450. We're hitting like almost 475. All right, can you see the results? Interesting. So for the first question, 32% of people say that surrogate decision makers do have an obligation to consent. And that's taking the position that surrogates actually have to honor what the FPA means, not just in the decision to donate, but also all the things that are required to optimize donation. 68% say no, they don't have an obligation to consent to all those premortem interventions and premortem decisions. It's a little bit different for the second questions. 20% say that clinicians and OPOs should proceed over objection, and 80% say no. Okay. Conclusions, and then let's get to Q&A. These are conclusions that I take, and hopefully that I've convinced you are defensible. Some are more straightforward. First person authorization authorizes donation in procurement after death. Only takes effect on death. First person authorization cannot be vetoed or revoked by others, especially after death. First person authorization is not informed consent. Even any decision to donate is not informed consent. Maybe it should be, but it's not. There's no additional information that's given about the process or the benefits or the burdens or anything else. And so it does not also address or authorize any premortem intervention or any other premortem treatment decision. It's only about donation after death. I think patient values should govern premortem care. And I think that should hold even if it precludes effective DCD procurement. It's my opinion. Um, it's because of this. I think it's ethically problematic to infer consent. This is consent, not authorization, because it's intervention before death. I think it's ethically problematic to infer consent to any premortem intervention on the basis of FPA alone. And I think that includes the timing, manner, and location of the withdrawal of life-sustaining treatment. I think it's ethically hazardous to accommodate this kind of creep without some clear boundaries or some consistent ways of dealing with it, because I think there's going to be a justice problem if we proceed in inconsistent ways. And that's also going to be a threat to trust. Um, I'll leave you with this. This sort of goes back to the title of the talk, when the gift of life might cost more than expected. Um, a lot of the folks, I sort of get become a broken record about this stuff with my colleagues, but I'm really convinced by um, the value of narrative ethics. Anyway, this is the way that I would, pose the question to you. Is the cost of losing control of the last chapter of your life, of the last chapter of your story, is losing control of the last chapter worth paying to give the gift of life? Because that checkbox doesn't tell you about all that other stuff that may be necessary to effect that gift of life. Okay, here are the references. These are really, really important, especially the Brendan Parent and Anelta's paper. All right.
Awesome. Let's dive into some Q&A. There's some fantastic questions coming into the Q&A. Thank you all so much. I want to start off with some more general questions. First, there's some folks who are asking about data. One, we have a data question of how many of our current organ donation, what proportion of that is coming from DCD?
I
Do you know off the
don't
top of your head?
know, actually. I'm not confident enough to say, but what I can say is that the trend is that the trend for DCD is increasing a lot.
I think
I
it's
don't
about
know if it's
50%,
50-50 yet.
Joel.
I don't think it's 50-50 yet, but
I think it's about there.
yeah, I think we may have approached 50-50. It used to be that brain death was the majority, the clear majority. And that's gradually changed. And I think it may be 50-50 now, but I'm not confident enough to say.
Mhm. Okay. We also have some people asking, like, what's the difference between DCD and brain death? Does this apply to brain death as well? Is there a difference here? What should we be thinking about with regards to brain death for first person authorization?
So, I mean, historically, part of the reason why we even have a concept of brain death was for the purposes of organ transplantation, right? And um, so all that to say, there's two discrete ways of being determined to be dead, either by neurologic criteria or by circulatory criteria. The thing is, if you're determined to be dead, if the patient is determined to be dead by neurologic criteria, that means that they've sustained only potentially irreversible loss of the function of their whole brain. It doesn't say anything about the rest of their physiology or anatomy, right? So it may be that if they're dead by neurologic criteria, that the rest of their physiology and anatomy is still functioning, which means that we can do all these other interventions on the brain dead person because they're dead. The dead and the living don't have the same rights,
Hmm.
right? And first person authorization takes effect on death. So they're dead by neurologic criteria. Physiologically, anatomically, they're probably in a pretty good situation to allow for procurement. So we can do the stuff like line placement, resuscitation, or I mean, what we should maybe call something else, but anticoagulation, all these other meds, all these other exams on what's already a dead person. You can't do that without consent for somebody who's not dead by because they haven't been determined to be dead by circulatory criteria. If they are going to be determined to be dead by circulatory criteria, you can only really do those things before death, either with consent, I would argue, or you have to wait until after they're dead, which is going to require that the heart and lungs stop working for at least 5 minutes, during which there's going to be a period of potential damage that to the organs that you want to procure.
Hmm.
And that's really the gist of the problem.
Hmm. All right, we have another question about data. Just quick, Joel, is there any data on how OPOs are engaging with this, or is this just experience that you have? Is there data out there is this a hypothetical risk, or is this risk actually happening where OPOs are superseding surrogate decision maker choices to prioritize FPA over what a surrogate decision maker would say is substituted judgment used for the patient?
Um, so I'm not aware of any formal study that systematically characterizes and tries to show a particular frequency of this over the system. There are increasing cases that we are aware of, some in the literature that show this problem. I can say that in our consult service, this has come up a number of times. And if other people know about literature, I mean, that would be awesome if you could let me know.
Yeah. And it seems like other people in the Q&A have expressed that they've also experienced this in their healthcare systems across the US. So I wanted to share one of Rebecca Martin's. She also questions, she also affirms that she's experienced this in her palliative care practice at a large academic transplant center. Her question is, why is it that a surrogate can make the final decision on behalf of a patient for any medical intervention, but are not able to override the decision for organ donation, which may have been made decades earlier, say, when the patient first obtained their driver's license?
So, I mean, that's just the nature of the law. And the law was written in a particular way. The argument for the law is not just that it might lead to more organs being procured, it's to protect the desire of the donor to donate and prevent it from potential intrusion or revocation by family that are doing it because they don't want it to happen, even though the patient would have wanted it to happen. That's the theory behind it. The Uniform Law Commission actually has a lot of justification for it in their commentary about this section of the Uniform Anatomical Gift Act. Um, but what's important here is that the non-revocation, the inability to revoke, only really has effect after death, right? There are some narrow circumstances where it might be different, but for the purposes of organ donation, it has to be the donor.
Okay. It brings into some questions that other folks have for about your presentation that are a little bit more suspicious or a little bit more questioning. Thomas Leventhal asks in the Q&A, I struggle with the last comment about decisions on choosing timing or donation.
Yep.
And in fact, if not honored, that this is a harm. This is the struggle. This seems to oversimplify donation to a binary decision, a yes or no,
Yep.
and doesn't account for the complexities of timing for organ allocation and availability of transplant teams to perform procurement to maximize the potential of the gift of transplant. So
Yes.
how do we balance or navigate the multitude of decisions that come up with organ transplantation when we only have FPA as a binary checkbox?
Okay. So, this is a colleague, and this is a transplant doctor who also runs our donor care unit. And I have a ton of respect for Dr. Leventhal. Here's the thing. In this presentation, there's an ethics focus, and it also really obscures a lot of the gray area because when we really start looking at the details of the way uh, acute care and critical care, particularly at the end of life, is the kinds of technology that are involved blur the boundaries of what we understand to be life and death and the conditions to which life and death happen, and the opportunities for being able to optimize procurement. I think Tom's point is right in that artificially making the binary to some extent, which is what I'm doing because it's more of an ethical analysis, is going to potentially artificially exclude what might be an ethical range of things to do to optimize procurement that's unconsented at the end of life, right? But what I'm worried about is not explicitly, as a community, formally and transparently doing it and just relying only on FPA to cover a huge swath of things that we don't necessarily even know we're able to describe or articulate to the community. If we can do that, I think that would be the best way to proceed. There are a lot of other potential ways of going about this, giving people more options, giving people more information, You can even go as far as to change the law to say and to tell people if you choose to be a donor, you don't get to choose this stuff anymore. This stuff is going to happen, possibly, right? You can't refuse. But it's just got to be transparent and it's got to be systematic. Given the way things are now, I think it's just really hard to defend doing a lot of stuff solely on FPA.
That brings us to another question a lot of folks have had for you, Joel, which is about legislation and changing legislation. So, one of our attendees asks that there's this, they point out that underlying your presentation is this assumption that authorization of donation somehow, right, there's conclusions by the OPOs that this somehow makes donation the primary value of the patient. And also noting and pointing out that maybe we shouldn't accept this claim, right? And so the question is, do you have a proposal for legislation that would allow patients to sort of say, well, donation here is a value of mine, but it's not the highest value, right? Distinguishing out that you still want your family to act in substituted judgment, but keeping in mind that if donation's an option, sure, we could do that too. How do we navigate that legislatively? Or is this only something that can happen through substituted judgment, surrogate decision making, and potentially advanced directives?
I mean, I think there should be both um, law and regulation that gives people a lot more uh, information and power over the decision to donate and what's going to be potentially required for the donation to be occur and be effective. Um, I mean, I'm sort of going to have to bail on this one. I think there's already a work group working on potential revisions to the Uniform Anatomical Gift Act.
Yeah.
One of our affiliate faculty, Thad, I think is on this. Um, there's a whole range of potential of legislative and I think regulatory solutions. And I'm actually personally okay with a huge range. What I'm really uncomfortable with is just the vacuum. And then with this gap, a sort of a categorical reliance on FBA to include a huge swath of things pre-mortem. And what is included in that swath, we don't necessarily know, right? Because then we can start doing a lot of things that might be harmful and might erode trust in ways that are actually more destructive to the whole enterprise, I think.
Right, all about how can we actually build trust. And I think that's really interesting because when you look at some of the data in Europe, right, between opt-in, opt-out systems, it's not like either one system really leads to more organs. But the data we do have is that Spain has put a lot of emphasis in clinical education and building trust, and that has actually increased organ availability for that particular nation. And so your emphasis on trust, I think, is absolutely right. Currently, right now, the DMV is not the place to do it. Totally agree. And I think we see in the comments more and more people are taking themselves off of the FPA DMD registry list. And that's a shame because it means that it reveals sort of the distrust growing in the organ transplantation enterprise. And as you
Yeah.
stated earlier, and I agree, organ transplantation is a good. It's a good to have in our society within our medical context. So that said, we've gone over. Thank you
I
so
want to add one
much,
more thing
Joel.
about the whole FBA
Yeah,
thing.
yeah, yeah.
For the people that are taking themselves off the donor registries, it may not necessarily be that they don't want to be donors. It
That's
just may
right.
be that they don't want to lose control of everything at the end.
That's right. That's right.
And so if they get rid of the FBA, they can actually write other stuff into their directive or tell their surrogate decision makers about the things that they're willing to do and the things that they're not willing to do to affect donation.
That's
It's
right.
just that they're worried about losing control of all of it if they have the FBA.
Or that it
Ideally,
would
everybody
be.
has like a comprehensive directive where they tell their surrogates exactly what they're willing to do and what they're not willing to do,
And I
right?
find too that a lot of folks aren't necessarily interested in losing control for their sake, but they're more interested in preserving that sense of control for their surrogate's sake,
Yeah,
right?
right.
They
Which
care
matters.
more about how their family members and their loved ones are going to interact with this experience than their own body. So thank you so much, Joel. Fantastic presentation.
Thank you.
I
Thank
want
you.
to say that we have a fantastic upcoming session with Jason Wasserman on slow codes, show codes, so navigating code status disagreements and policies. We also have some fantastic courses. Joel and I are co-teaching next semester, next fall. We're thrilled. And our other faculty, Dr. DeBruin and Dr. Needle Suarez, will also be co-teaching. So please register if you are looking for courses. Come join us in those classes. And thank you so much for joining us today. Look for our further webinars. We have, our UBB webinar coming up this summer and further ethics grand rounds webinars as well. So thank you so much for joining us and have a great day, everyone.